இங்கு இஸ்ரேலியருடைய கப்பல்களை பாதுகாப்பதை விட்டுவிட்டு கடற்படையை பாவித்து குறைந்தபட்சம் இந்த பாதிக்கப்பட்ட வெள்ளத்தினால் மிக மோசமாக இன்று இந்த பாதிப்புகளை சந்திக்கின்ற கிழக்கு மாகாண மக்களுக்கு அந்த உதவிகளை செய்வதாக இருந்தால் அது மிகப்பெரிய ஒரு உதவியாக இருக்கும். தற்போது கிழக்கு மாகாணத்தில் குறிப்பாக முல்லைத்தீவு புல்மோட்டை தொடக்கம் பொத்துவில் பானமை வரையும் எல்லா கரையோர பிரதேசங்களிலும் அதே போல தாழ்நில பிரதேசங்களிலும் கடுமையான மழை காரணமாக வெகுவாக மக்கள் பாதிக்கப்பட்டிருக்கிறார்கள். அங்கு நீர் வழிந்தோட முடியாமல் பல இடங்களிலே நீர் தேங்கி நிற்பது மாத்திரமல்ல, போக்குவரத்து பிரச்சனைகளும் மிக உதாகரமாக உருவெடுத்து வருகிறது. மக்களுடைய வாழ்விட பிரதேசங்களிலே இன்று நீரை அகற்ற வேண்டிய நிலவரமும் கிணறுகளை துப்புரப்படுத்த வேண்டிய நிலவரங்கள், அதே போல பயிர்களுக்கு ஏற்படுகின்ற சேதங்கள் குறித்த கணிப்பீடுகள் இவற்றோடு சேர்த்து அவசரமாக பாதிக்கப்பட்ட மக்களுக்கு அவர்களுக்கான சமைத்த உணவை வழங்குகிற முயற்சிகளில் இந்த 3 மாவட்டங்களிலும் அரசாங்க அதிபர்கள் அதற்கான கணக்கீடுகளை செய்து அந்த விஷயங்களை துரிதப்படுத்துகின்ற நடவடிக்கையை மேற்கொள்ள வேண்டும் என்று இங்கு அரசாங்கத்திடம் வேண்டுகோள் விடுக்க விரும்புகிறேன். இந்த சந்தர்ப்பத்திலே அரசாங்கம் செங்கடலுக்கு எங்களுடைய கடற்படையினரை அனுப்புவதற்கு, அதுவும் குறிப்பாக இஸ்ரேலியர்களுக்கு ஆதரவாக அவர்களுடைய கப்பல்களை பாதுகாப்பதற்கு செங்கடலுக்கு எங்களுடைய கடற்படையை அனுப்புவதை விடுத்து கடற்படையினரை இவ்வாறான அனர்த்த நிவாரண பணிகளில் அவசரமாக ஈடுபடுத்துவதுதான் மிக உசிதமான விஷயம். இதிலே ஜனாதிபதி அவர்கள் கவனம் வைப்பார்கள் என்று எதிர்பார்க்கிறேன். நேற்று ஜனாதிபதியுடைய அந்த நடவடிக்கையை கடுமையாக நான் விமர்சித்திருந்தேன். இந்த நிலையில் அவரிடம் இன்று நான் விடுக்கின்ற வினயமான கோரிக்கை, இங்கு இஸ்ரேலியருடைய கப்பல்களை பாதுகாப்பதை விட்டுவிட்டு கடற்படையை பாவித்து குறைந்தபட்சம் இந்த பாதிக்கப்பட்ட வெள்ளத்தினால் மிக மோசமாக இன்று இந்த பாதிப்புகளை சந்திக்கின்ற கிழக்கு மாகாண மக்களுக்கு அந்த உதவிகளை செய்வதாக இருந்தால் அது மிகப்பெரிய ஒரு உதவியாக இருக்கும் என்று இங்கு சுட்டிக்காட்ட விரும்புகிறேன். Mr. Presiding Member, I know that the Honorable Minister has been for some time now seeking to legislate a multitude of enactments on many an aspect of the law, and among such enactments I would say is the all-important bill that is before us today is the Contempt of Court, Tribunal and Institution Bill. The bill eloquently states in its long title that it provides for the uniform application of the law relating to the contempt of court, tribunal and institution, and it also says that it provides for the procedure to be followed. So, Mr. Speaker, the purpose seems to be twofold. One is to provide for specific law on contempt, and the other, having provided for the law, is to provide for the procedure to be followed in the contempt cases. The question whether there should be a specific law for contempt has been around not only here but in other jurisdictions as well. There was this controversy in India, but it was settled way back in 1971 through the Contempt of Courts Act in India. As one goes through the Supreme Court determination in August 23, when this bill was taken up for Supreme Court determination, this has been one of the main arguments in the Supreme Court, that can you pass a specific legislation on contempt when there are constitutional provisions and even other enactments that penalize contempt of court? Now, we know Article 105 Clause 3 provides for contempt matters, and we know our colleagues Ranjan Ramanayaka and S.B. Disanayaka both had to suffer the consequences of this power vested in the Supreme Court. Mr. Ranjan Ramanayaka, our colleague, said that 99% of the judges are corrupt in the country and had to face incarceration for 4 years and more, subsequently reduced to a few years. Then S.B. Disanayaka, who had called one of a judgment as Balutindu and had to be convicted and confined to prison term for 2 years. Apart from the provision, the constitutional provision, there are other separate enactments that provide for contempt to be instituted against individuals. For instance, the Civil Procedure Code, Code of Criminal Procedure, then Primary Courts Act. Then we also have Partition Law, which provides for that. Judicature Act provides for it. Therefore, these are few examples which where the already provisions exist. But then, so the argument was made in the court that this parliament does not enjoy the legislative competence to enact a separate legislation on contempt. But the Supreme Court pointed out that the reserved list preserves the right to pass a separate law on contempt. In the reserved list, list 2 of the 9th schedule, under the heading Justice insofar as it relates to the judiciary and the court structure, it had very clearly provided for subsequent enactment to deal with the contempt of court matters. So this shows that as far back as the enactment of the 13th Amendment, that we had had this provision to make room for a new legislation in this regard. With that controversy settled, Mr. Speaker, the question arises whether what this law seeks to achieve. I have looked at it very carefully, and I would like to say that the offence of contempt was always in a state of uncertainty. While some acts amounted to contempt, others did not do so. We remember the old case where the editor of a newspaper was summoned and punished for contempt for writing about judges spending their time in Nuerelia. He captioned this article as "Justice on Holiday." He pointed out in public spirit, as he claimed, that judicial time was being wasted, but the judges of yesteryears would not let him go scot-free. I remember the case in the matter of Armand de Souza, editor of Ceylon Morning Leader in 1914. It reported in 18 NLR 33. But this all-important judgment recognized one important aspect of law of contempt of court. I quote here, "There is no doubt as to the right of any member of the public to criticize, and to criticize strong judicial decisions or judicial work, and to bring to the notice of the proper authorities any charge whatsoever of the alleged misconduct on the part of a judge." So the judges in 1914 pointed out that you can criticize a judgment or a judicial work and even misconduct, but to the proper authorities. But you cannot comment on a personal holiday time that a judge is entitled to. So that being the case, so the bill now provides for some acts which would amount to contempt of court. For instance, it sits down in clause 3.2 that willful disobedience to any judgment, decree, direction, order, writ, or other process of court will amount to contempt of court. Even a willful breach of an undertaking given to court will also become contemptuous. So what the bill is seeking to do is to put a statutory footing all that the judges have said in their decisions in the past. In other words, the common law principles that have been set down in judgments are being confined to and codified to some extent in this bill. We have no quarrel whatsoever as this legislature puts on a statutory footing the legal principles that have already been laid down by judges in this case. Now, another aspect which I would flag, what is meant by scandalizing judicial authority, as this is sought to be made an offence. This tag, scandalizing or lowering the judicial authority in clause 3.2c of the bill, is in my view an unruly horse. Though the Supreme Court has affirmed its constitutional validity in the bill, one cannot lose sight of the fact that the contours of scandalization are quite uncertain. The person who commits the contempt is left to the discretion and vagaries of the particular judge who hears his case. It's up to their adroit arguments of counsel to take particular act outside the ambit of scandalization. So this issue, there has been some criticism even when this bill was taken up on the last day. That is why the debate was adjourned for today. Therefore, we would like
Honorable
the
Member,
Minister
you have 2 more minutes.
Have a revisit of this matter. Beg your pardon?
2 more minutes.
Yes. Now, I was reading an interesting episode in Lord Denning's book, The Due Process of Law. At page 6, he narrates an interesting story that took place before him. It is worth quoting. Lord Denning says, "When I was presiding, we became more lenient. On every Monday morning, we hear litigants in person. Miss Stone was often there. She made an application before us. We refused it. She was sitting in the front row with a bookcase within her reach. She picked up one of Butterworth's workmen's compensation cases and threw it at us. It passed between Lord Justice Diplock and me. She picked up another that went wide too. She said, 'I'm running out of ammunition.' We took little notice. She had hoped we would commit her for contempt of court just to draw more attention to herself. As we took no notice. She went towards the door. She left saying, "I congratulate your lordships on your coolness under fire." So this is what Lord Diplock said of how magnanimous judges have been. Because, this is not an issue for ego of the judges to be punishing people for contempt. And then similarly we have issues relating to matters that are said in this house. We have our Parliamentary Privileges Act. There are sometimes some members stepping outside the limits of criticizing a judgment in a proper sense, but going beyond the ambit of criticism and then taking on judges and then trying to criticize their personal conduct. Even recusal of judges, recently one member of parliament had gone beyond the limits, and then these issues I had in the past taken it up. Therefore, Mr. Presiding Member, let me wind up by saying, once again, quoting Lord Denning in R versus Commissioner of Police in 1962, Queen's Bench Division 150, this is what Lord Denning says: "Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity. That must rest on sure foundations, nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it, for there is something far more important at stake. It is no less than freedom of speech itself." Though Lord Denning was magnanimous, this freedom cannot be the freedom of the wild ass. Article 15(2) of our Constitution specifically states that we cannot exercise the freedom of speech to commit contempt of court. Having said that and quoted that, I would say that this was a long-felt need to have a proper contours defined as relate to contempt of court, and I thank the Honourable Minister for having brought that, as well as various other pieces of legislation to prevent frauds in this country, and that too is to pass today. Therefore, I commend the Minister for having introduced these bills. Thank you.